Good morning, everybody. It's Positive Tuesday today, December 12th, 2023. I don't know where Fitzy is. We don't know. But for Barron County Sheriff Chris Fitzgerald, I'm DrydenWire founder Ben Dryden, and today we are being joined by Sawyer County Judge. No, that wasn't him. John Yackel. Where, of course, we'll be picking his brain on several things, including, of course, cash bonds, because that's a fun topic here on Positive Tuesday. But first, it is Positive Tuesday with Ben and Fitzy, which is presented by Professional Exteriors and Interiors. With 20 years of experience, this locally owned and operated business provides quality work both on the inside and on the outside of your home or business. Like Fitzy and I, they believe that it's the little things that make a big difference. Give them a call today. The number's right there on the screen, 715-520-2271. This is the part where I say, Fitzy, good morning, how are you? But as everyone can see, he's not here right now. So, yeah, he's running late. He'll be apparently joining us here shortly. So, John, how are you?
Morning, Ben. How are you? Or should I say Superman?
Yeah. It's my lucky Superman shirt. I only bring this shirt out when it's, we have the best guests.
Oh, thank you.
Yeah, you're very welcome. And good morning, Renee. Oh, I got that screwed up. Anyway, I was looking when I put the preview up yesterday, announcing that you were going to be on the show, joining Fitzy and I when he joins us here in a couple minutes. I went back and I looked, and this is your 8th time that you have appeared on DrydenWire. This is the first time that you've ever been on a Positive Tuesday Ben and Fitzy show, and I've always asked you, it'd be great if you could come on a Tuesday with us. It'd be great if you come out, and your answer is always no. So what changed? Not no as in I don't want to be on with Fitzy, but what changed? Because you're always the busiest day on Tuesdays or something.
That's right. Tuesday before August 1st was always one of those days where we had our criminal intake days, and those were always the busiest days of the week. Since August 1st, Sawyer County has now become a 2-judge county, and so that means that at least as far as the Tuesday intake goes, I'm on for 2 Tuesdays, and then I can deal with other things on Tuesdays, and so the other branch is dealing with those busy criminal intakes. So at least I have a little bit more time on Tuesdays now.
So for people who don't know, what's an intake day?
Well, that's where we schedule the majority of our criminal matters, ones that are already in the system to come back for statuses, preliminary hearings, pleas and sentencings, final pretrial conferences, all cases to try to advance either to a jury trial or to have those matters resolved. And the reason why we only really have them one main day of the week is because we share the public defenders that have to represent a lot of these individuals with other counties. Our public defender office is out of Spooner, yep. And they serve Washburn County, Sawyer County, and Burnett County. So we have to share them with those other counties.
Okay, so intake is on Tuesday.
I think Washburn is on Monday and Burnett's is on Wednesday.
So what's the difference between intake day and the day that you set cash? But if you get arrested on a Saturday, yep. You don't appear before a judge, of course. So I would assume I thought you just appeared on a Monday. So what's the difference between whatever that's called and intake?
So if you get arrested, we basically have the larger counties have it every day. We have it on Monday, Wednesday, Fridays, so that at 11 o'clock. So that's where we take care of all the new arrests, whether it's a new possible crime or if it's on a warrant because they didn't come to court. If you get arrested over the weekend, you will have intake in Sawyer County at 11 o'clock. If you get arrested on Monday night or Tuesday night, then you'll have it on Wednesday at 11, and then we have also Friday at 11.
Got it. Hey, good morning, Fitzy.
Morning. Sorry, Your Honor. I'm late.
Good morning, Sheriff.
Oh, my goodness, that's right. We're on a title. That's right, Sheriff and Judges. I keep forgetting. I'm used to first names.
That's right.
Yeah. So we were just talking about intake day and what that meant in cash bonds, etc. But first, explain to people why you're 7 minutes late. You're in a suit, for crying out loud. What's going on?
I got to impress the judge. You always dress to impress.
I love it. Just for you, John.
I was at my last chamber meeting today, and we got into some discussion, so I had to stay for that. So,
what do you mean last? Are you quitting the chamber?
Yeah, I'm leaving the chamber board. There's some members of a business that want on, and my position was up, and I said I'm willing to give my spot up. I'll still be involved and do some things with them. But I enjoyed the Chamber of Commerce. My last, I think I was on for 9 years.
Jeepers.
Yeah.
Well, welcome to the show.
Thanks. We won't have this problem anymore now.
Yep. So what John was saying is that now they have a second judge, he has half the caseload, so he just works Monday, Tuesday, and half Wednesdays. And then the other judge just works Wednesday afternoon, Thursday, and Friday. I'm pretty sure that's what he said.
You could borrow him down in Barron County, have him come down here 3 days a week.
I wish that were the case, but it's not the case. There have been, because of the accelerated caseload Sawyer County's had for a number of years, there is plenty to do. There are plenty of things that we have dropped off along the wayside that we just didn't have time to address. One of them is our new treatment court that's going to be starting up here in January.
That was going to be my question. Are you able to do more preventative work, or what we hope is preventative work in the world of prevention?
Over the last 5-6 years, we've been moving from, where that traditional drug court model is that you give people help after they get convicted. I think the system is trying to move towards at least some accelerated help for people. They get picked up on a weekend with possession of methamphetamine in Sawyer County. On Monday, when your bond is set, you're going to be in front of what's known as Justice Point for certainly some pretrial monitoring as far as drug use. And then more importantly, they're there to kind of be a funneled, hey, if you're serious about your sobriety, we're going to put you down, here are the facilities that will be able to help you and give you some outpatient treatment. So at least you're getting some exposure on drug addicts into the system, see which individuals can maybe self-correct, which ones need a little bit more intrusive therapy. And then with our recovery court, that just gives us another ability, a little bit more of an ability to help people along the system. Because there are some, like I said, who can self-correct, some who need in-community treatment. There are some that need maybe probation and the services they offer. Drug court is something similar to that, where it's a little bit more intensive. And then the other options are inpatient treatment, and then ultimately prison, in a confined setting with treatment. And obviously that's more expensive as you get further down there. We're trying to be as financially responsible as possible, getting people the help that, if there's some people that can be helped cheaply, basically, then you want to get the appropriate help to the appropriate people wherever they are.
Is this something that is received well by the community, this type of treatment and drug court type scenarios?
To be honest, in order to get the second judge, Sawyer County had to commit to a recovery court. So whether or not it's popular or not, it was something that was required. There's sometimes a perception that recovery courts or drug courts are the end all be all, and that's going to save the community. And the reality of it is very time intensive. It suffers from every other type of treatment, is that, it's variable. Sometimes it works great. Sometimes it doesn't. It depends on the individual. But what it is a sign of a healthy court system where you have options. Hey, you didn't self-correct. You haven't been able to stay sober, but you're not prison bound. So let's try to get you help in the community, but through a drug court, a little bit more intensive supervision, working with treatment providers and working with the court system and things like that. And it's a different point of view. I mean, it took me a while to wrap my head around the concepts and what we're doing. And once I did get my head wrapped around it, I mean, I think it's a good addition. It's not a, hey, everything's good now, we're not going to have any problems. No, but for the people that are in drug court, it has the ability to really significantly impact their life.
Fitzy, do you agree with that down with the drug court system, what you have down in Barron County as well, and what the judge just said? Do you agree? Are you in support of this?
Oh, yes. And that's a very tough concept, as the judge pointed out, to wrap your head around, because law enforcement doesn't like change. We like people to go to jail for what we arrest them for. Yeah. We don't want the judges to throw the book at them. And we used to look at it, our drug court, and our drug court is still in now. We have a family court, and that's very successful. We used to look at it as from a statistic-driven thing, and I just gave a talk Sunday night. We have all our jail volunteers got together for a banquet that the Law Enforcement Foundation, a local church, put on. And we had over 50 volunteers come, and we have over 35 programs in our jail. and to help people get out of jail, not come back to jail, whatever the answer is. But we looked at drug court as being unsuccessful because we weren't at 70%. We weren't at 80%. Drug court was sometimes 10%, 20% success rate. Then we looked at it from a standpoint of, if we help one person get their kids back and go home with their kids, we save human services a ton of money. We save the jail population a ton of money. We save just a family being together. It's priceless. So we started looking at it from a one-on-one basis, and I think that's where I got some more buy-in from law enforcement and the whole system as a whole.
I'm trying to figure out how to ask this. Okay, I gotta be sensitive about how. So what is for both of you? Actually, John, is this a 5%? It works. How do you measure this? How do you know if it's successful? This just started. So do you? Is there something like the end of the year we know this is working because of X or Y or Z? How do you measure this?
It's difficult, and that is, everybody always wants a measurement, and it's not that simple. The way I look at it, and I guess the way I'm approaching it, is what I've learned over the last 8 years is, at first it was, all right, you're charged with a felony, possession of methamphetamine. All right, you're on bond. You get the benefit of a signature bond. Go get some treatment if you can't stop using. All right, it was, that's it. You have to stop. And if you don't, then, you're going to get in more trouble. And the reality of addiction is that, you don't want to set your expectations so that you're going to fail. And the expectations are, hey, you got caught now and you got to stop. And that's, for these people who are addicted to something like methamphetamine, they can't. It's impossible. And so you start realizing that. And so what, at least from the judicial viewpoint of it, what I want to start doing, or what I have been doing, is just viewing it in, are you engaged in your sobriety? Are you acknowledging that you have a problem? Are you trying to address it and getting the resources that you need? Are you at that point? Because there's a revolving door with addiction, is that you're going to use it, or you're going to use again once you stop, and then again, and then again. But what you want them to do is, every time they really put forth that effort, you want them to learn something, whether it's something along the lines of, hey, I've been able to open up to a counselor about why I started using in the first place, some trauma that happened to me when I was growing up. You express that, and they all of a sudden they start using again. But then when they go back into treatment, or they get some more help, then they've already got, I call it like an arrow in your quiver. You accumulate all these things, and then finally you make that push for sobriety. And so there is a lot learned that I've discovered in attempts at sobriety, even if they fail again, or if they slip up and they go back to using. You encourage them, you want them to get right back into sobriety and go through that process. And that's the reality of it. And if you just say, you got to stop using, that's it, you're going to be disappointed, because you're not going to be able to get any successes. And so even if somebody drops out of drug court or fails in drug court, you hope that they've learned something that will help them along the way, ultimately to finding sobriety, bettering their lives, and by virtue of bettering their lives, bettering our community's life. The better they do, the better we all do. And it's kind of a group thing. So it is very difficult to measure.
But are there people that take advantage of this? And maybe by people, I just mean maybe lawyers too, where it's hey, just go through and just do this, and then you won't get in as much trouble. Is that who picks the people, or can anybody, when they're going through something? Is it scenario based? How does that work?
Well, you have a drug court team that's consisting of defense attorneys, prosecutors, judges, treatment providers, all law enforcement, up and down the line. And it's possible, I suppose, for a defendant to go, I want to be in drug court, and to think that they're going to be able to game the system, and they might be able to attempt it. But really, we're there for their benefit. And if they're gaming the system, this isn't about, when you get into drug court, it's not about punishment. It is about, we are trying to help you. And if you want help, then you're an appropriate person to be here, even though you're having a hard time, even though you're struggling. But the ones that are there just to game the system, they're identified fairly quickly. We're all in the system been long enough that we can identify somebody who's not really, committing to this or just blowing it off, and you give them opportunities, and then they're just ultimately hurting themselves.
Yeah, and when was the other judge, the second judge in Sawyer? Was that just this August, or was it the year before? What? It was just which one was it?
Judge Isham took over on Branch 2, newly created Branch 2, on August 1st of this year.
Of this year, right. So this is something that kind of came with it. What Fitzy was talking about, the treatment and the drug, or the treatment stuff.
It's been in the works for a year or two, but until we got that second judge on board, it was difficult to implement just because of lack of time and resources.
Yeah. So as of now, it's been 5 months, 6 months since August. Probably too early to tell, but so far, is it like, okay, thumbs up, or is it's a work in progress? We'll get there.
Absolutely. For every judge, there's a period of time where you're learning. I guess you're learning the role and how to do it, and she has done a great job and is absorbing her caseload. And
sure.
I think just if not, she's darn close to being up to full speed.
And how does that work? Because before you were a one-judge county. So you would do you do the bail hearings, you do the intake stuff. You would be obviously assigned to the case, with exceptions of certain. Obviously, there's always variables there, or exceptions to that. But that's just how it was. And now, how does that work now? Like, do you? I think you had mentioned at the very beginning, almost like take turns on intake days or something like that. And then who decides who's presiding over a case? How does this whole thing work?
Well, obviously, it's different from county to county. There's no one size.
I mean, for you in Sawyer, with now two from one.
And we might be different than other two-judge counties, but
I see.
Created a system where we take parts of it from other counties. We're 2-3 judge counties. So we have intake, and that's and a judge signed to it. And so we go in 2-week intervals. And the judge that's on intake will hear the bond hearings, the new arrests, sets bond. And then, we don't know at this point which judge these cases will be assigned to. So if there's a cash bond on somebody, that judge will set it on the next intake so that it can be heard and the case can be processed and moved along. And if it's in Branch 1 or Branch 2, then that, on the next calendar Tuesday, that branch will hear it. But once the criminal complaint is filed, then we know which one it belongs to and which branch, and then it will get scheduled accordingly. So
how do you know?
It goes kind of back and forth, and how it is determined is random. It's there's a program in CCAP that when a criminal complaint is filed, that it will just automatically assign Branch 1 or Branch 2.
Hey,
speaking
like
winning the lottery every week.
Well,
am I going to get it? Am I going to get it? No.
I want to win this lottery. So
yeah. Hey, speaking of 2 judge counties, Barron. So obviously there was a situation where Judge Bittney had retired. I think that was September 15th. There was several interviews. Everybody probably knows this whole thing, so I'm not going to go and rehash it all. But when you saw that there was typically 3 judges in Barron County, those are the positions for it, but there's only been 2. That's been since September 15th. Since Judge Bittney has been retired, they still haven't had one yet. Do you follow this? Do you look at this just because it's an area county? And do you kind of see it as how could this impact Sawyer County? Does it make more work for you? I don't know. The whole thing's kind of a dumpster fire, and I'm just kind of wondering what your thoughts are on it.
It's pure speculation as to why the governor hasn't appointed. But just from a practical standpoint, obviously, if you're down one judge for a number of months, that puts stress on the system. It puts stress on the Barron system, and it puts stress, I guess, mostly on those judges. But then all of us in a district as a whole, because if you're down a judge or 2 or 3, that puts a strain on trying to process cases in an appropriate amount of manner, and it just, like I said, it adds stress to the system. But I know that Judge Boyle and Judge Babler are absorbing it and doing it and covering it, and they know that at least the latest that they have to go is August 1st of this year. Of 2020
coming up here, right?
But hopefully it'll be resolved sooner than that, and they can get some relief. I knew, otherwise I know that they're using some reserve judges to fill in gaps and things like that, and they're doing what they have to do to manage it. But a body there, an appointment would be more beneficial to the system overall.
That's a very political answer, Fitzy.
Yes, it was. It was just what I would have said. I agree.
All right. Well, I want to get to cash bonds. We talk about that on the show quite a bit. We'll get to that in 15 seconds after a word from Spooner Health.
Satisfaction surveys and in conversations with patients, they appreciate the fact that staff got to know them. Staff really took their preferences into account, and they just feel grateful that they are being cared for as a person.
To learn more about our services, visit SpoonerHealth.com.
All right, so before we get into the actual cash bond part, I thought of a question literally just during that commercial. What is the signature bonds? I don't understand it, but I don't want to get too far down that rabbit hole of what signature bonds, etc. But I have a question. What is the virtue of a signature bond? What's the goodness in this? Why do we have them?
You're asking me.
Well, yeah, I'm not going to ask Fitzy. What is the virtue?
I'll answer it first.
Okay, Fitzy, go ahead. You answer it first, Fitzy.
I think it's just because some people, I mean, in my opinion, what a judge does that is they think the person's not going to commit the crime again, and it wasn't a serious crime, and here's your chance to go out and make it and be good again. I don't know. That's in a simple terms. That's what I would say.
See, and I don't understand it at all. I think we shouldn't even have them. Specifically felony, because that's what usually when Fitzy and I are talking about something, Fitzy doesn't send out a press release about a dog or something that isn't a felony case or something. A dog was barking. Here's a press release. They called it in. And when I do stories, they're typically, CFs, the felony, criminal felonies. I don't understand why we have signature bonds. And I don't mean that sarcastically. I literally don't understand the virtue of a signature bond.
Oh, and there you go. You throw me off again at the last word, virtue, the virtue of it.
The goodness of it.
Well,
right. Why do we have this?
So bond is designed to assure appearance in court because, let's just clear the table and start exactly what's going on here when you're talking about setting bond. You're talking about very early on in the case. Somebody might just have been arrested, all right? And you don't even have a criminal complaint, at least in some of the jurisdictions. Mm-hmm. You have a probable cause statement, which is a statement written by a law enforcement officer as to what their experience was with this individual, what took place as far as they're aware of. And you have to set bond on that. And remember, they're not charged, they're not convicted. And so you really have to start from the viewpoint of, well, wait a second, how can I force somebody to or set a cash bond and make somebody sit in custody for a long period of time, potentially, just because somebody says so? And, I know the public viewpoint of cash bonds is that, all right, yeah, you know what, they arrested him. Yeah, he's good. Why do we need to give him a trial? Well, that's what separates us from, the other countries of the world, whereas, the presumption of innocence before being found guilty is incredibly important. And pretrial detention is only to be used sparingly. And you got to remember every time they're not convicted yet. So, there are some limitations on when a judge can use a cash bond. And those are, it's not just simply, all right, they're charged with child sexual assault, and so large cash bond and
yep.
Case is over with. No.
Well, I don't know about the case is over with, but there better be. I'm sorry. When it's anything against a child, man, there better be a multi-$1,000 and it better be a cash bond, or I freak out when I see that.
And so what happens, though, is that you have to look at the specifics of what information the judge has in front of them at the time. There might be an allegation that is old, that isn't very supportive. It's just a lot of things going on, context that that does not justify a cash bond. And you look at all of these factors together, and they're not always. They might be in the probable cause statement. They might be the history of someone. You look at someone's history, and you have two cases that are similar, child sexual assault. And you might have one person who has zero criminal record, who is, the head of the chamber in some community. And then you have somebody who is a drug user, multiple felonies, maybe other sexual assault cases. And you look at those two and it's like, do they justify the same bond? Well, you've got to look at what the allegations are, who's making the allegation. And so it's a very complex fabric of decision-making in a matter of seconds to be able to formulate what is an appropriate bond that survives review, that is responsive to our Constitution, to the rights of the defendant, and also to the protection of the community. I mean, if there's strong probable cause and there's very strong evidence in a probable cause statement as to why a cash bond is important, then a judge is probably going to impose a cash bond. If it's not, when it goes into the press, it's, oh, well, this person's still charged with it, and what, they got a signature bond? Well, I mean, you're not always privy to the information that the judge has
Correct.
in front of making the decision, and that's
Yep.
the biggest thing that doesn't translate to the
Yep.
general community is that the law is complex, and if you're not in it all the time, you don't always know what's going on, and we all have our assumptions as to why a judge does one thing or what the system is, and
Yes, I
it's
do.
very popular now to criticize the court system. I mean, I was at a function not too long ago about fentanyl use, and somebody was, lauding our sheriff and saying, what about the court system? Why are they not, stopping these people? And it's like, well, you just kind of gave us the example. We're not meant to stop it. What we're, at least not at a certain point along the way, we're meant to make sure that the system is being run fairly, that people are given their due process. And then if they're convicted, then we have a responsibility to impose a sentence that is appropriate with what the charge is and the circumstances of the case.
Well, I guess I just don't understand. So there's two parts of this, right? There's the actual amount, whether it's signature or cash, but first part is the amount. So then the second part, of course, is a cash or signature. What I mean literally is, why do we even have a signature? But why can't we just do like a $20 cash bond? Like, what's the point of even having a signature bond? Why can't we, judges be able to look at just the total amount?
So the vast majority of bonds are signature bonds. And so what happens is that, okay, somebody gets arrested over the weekend and they have a tiny bit of methamphetamine. They're a drug user. They haven't committed any other crime other than possession. They're going to get likely a signature bond in Sawyer County with the conditions to check in with Justice Point, to begin this pretrial monitoring, to go through drug screening, and to go through a screening to determine what level of need they have for treatment, all these things. And hopefully they start learning and we get them into sobriety. Mm-hmm. And so if they're on a signature bond, let's say a $2,500 signature bond, what that does is that they go sign their bond. And if they don't come to court at some point along the way, the court can take judgment against them for $2,500. And so they might come out of this case with an added $2,500 burden, a financial judgment. Are they going to pay it? Well, I don't know. But that's what it does. It's meant to assure their appearance in court. You don't need to have bond. This person's going to show up. This person has a signature bond. Well, if you don't show up, you're going to have a financial judgment against you, and then you're going to be potentially on a cash bond anyway. And it's a system that is not foolproof, but I mean it's designed to try to, because you have people that legitimately miss court. My car broke down. I'm in the emergency room because my kid's puking. All right. We didn't know that at the time, so a warrant's issued for your arrest. They make a voluntary appearance, and we just reinstate the bond. But if you have a disorderly conduct or a fight with somebody, and it was a one-time thing, well, why are you going to put a cash on somebody? We're confident that they're going to at least be given the opportunity to have a signature bond go out and not commit more crimes. And it's not an easy system, but no. Cash bonds are not something that should be, pretrial detention is not something that should be taken lightly, and that everybody should just be sitting in custody awaiting their day in court. First of all, because it's against the Constitution. I mean, pretrial detention, then you don't think that could be abused? Right. Oh, well, Ben Dryden, he did this, and so, we're just going to put you on a cash bond that you can't afford, and you can sit in there. Just because it could be very much abused if the safeguards were taken away. Mm-hmm. But it's all about getting them into court and having what combination and how many times do they miss. It's personal to each judge, and I know that I would have a lot more time if I weren't dealing with people who missed court and then make a voluntary appearance and say, I missed for this reason. It's like, oh, okay. Um, it's complex. It's not as easy as just a $2,500 cash bond. That's it for child sexual assault. Wait a second here. That statement, that I've seen on numerous platforms, that really doesn't take into consideration all of the things that are going on, and ultimately the fact that people are innocent until they're convicted.
I get it. I still don't like seeing signature bonds for some kids. I'm sorry. You'll never turn me around on this one. Fitzy, what are your thoughts?
But with the new bond ability for judges,
right.
I think we've talked less about it in the last year than we've ever had before.
Yeah.
I think judges have had another tool in their tool belt, and that's what we needed to give them, and that's what Wisconsin voters gave them, and that's what we needed. It's a tool in their tool belt. I think they've used it appropriately, at least in Barron County. I feel confident our judges are using that tool to benefit the community.
Yeah, for people who don't know, John, so there was a referendum in Wisconsin, I think it was last April. I can't remember, there was two different ones. I think they both got passed. What was that?
Well, really, before it changed, it was just basically to assure appearance in court. And, then how can you justify a cash bond if they've never missed court? Well, have they ever been charged with a Class C felony before? There were ways to impose cash bonds, obviously, because judges did. Now with the change, judges are better able to consider things like the risk to the community. Is somebody trafficking drugs in from Minneapolis? 200 grams of methamphetamine. All right, that's more of a threat to the public safety than, let's say, domestic disorderly conduct. Between two individuals that live together, and they get into a little bit of a fight. All right, that's a misdemeanor. You're probably not going to impose a cash bond. You might take a second look at it if it's a trafficking with a large amount of drugs coming into the community, sexual assault, things like that can put random people. OWIs, when you start getting past 2 and 3, that's people look at that. And then it also is, you're able to look at their criminal history as a factor in determining that. Does this person have a large rap sheet that might be taken differently than somebody who's never committed a crime, and now they're alleged to have committed one?
Well, so as Fitzy said, that this is another tool in the proverbial toolbox. Yep. How much have you used that so far? Have you noticed, have there been times, without any specifics, but since it was passed in April, I think it went into effect right away. So I don't think I had to wait any longer. So it's been, I don't know how many months, 9 months, 8-9 months. Have there been times where you are in that situation and going, you know what, I'm really glad they did that? I mean, how much has this actually impacted so far Sawyer County in the cases that you're presiding over, or you are doing the bond part of? Using it a lot or not so much?
I don't know that it's had any dramatic effect. I've been a judge who, if I felt that it was necessary, used cash bonds, still use them, and still use them in most of the situations that I think are appropriate. If anything, this has given me, if I use them, and when I do use them, I will just know that I have a little bit better, I think, of a rationale for doing it. I think it just gives a judge just a little bit more solid footing in using it. But does it have any impact? I'm not aware that it does. I think judges still look at the facts that are before them, the circumstances, and I think judges, if they were inclined to impose a cash bond in a set of circumstances before, will still do that, and maybe just have a little bit more satisfaction that there's some rationale. And if they didn't think that it was justified before, they're not going to be changing it now. Mm. So, I mean, I think it's good to have more clarification as to what judges can use in setting bond. I would be surprised if there is evidence that it's really had a dramatic effect in the way that judges do that.
Yeah, I don't think it's had a dramatic effect, but it's had in Barron County. I think it's had some effect, and it's given maybe again. I agree with you, Judge. It's given the judge some benefit, and the defense attorney can't say, well, he's never missed a court date, Your Honor, so you have to let him out on signature bond. And which was, I don't want to say was the rule before, but was kind of written in the law that way, and that's what was changed to help judges, again, not have to defend it so much, maybe. And so I think that was a great way to put it. So I agree.
John, Fitzy had brought up, so I'm putting this 100%. I'm throwing you under the bus here, buddy. Okay. Fitzy wants has brought up the idea of potentially, maybe, perhaps, some of that money that somebody has to pay in, they don't show up for court, whatever, etc. Maybe going to some law enforcement. What are your thoughts about that? Because first of all, how often does anybody actually end up having to pay for it? I still really can't find an answer on a percentage. I wish we'd know, like, okay, this county, here's a percentage of people who don't show up that actually have to forfeit their bond that they have placed, either signature or cash. But I don't even know where it goes. It just goes to clerk court's general fund, right? But then what? So I don't even know where it goes.
That's a question left more for the state court system and the clerks, because there is a whole pie chart as to what's forfeited or on fines and things like that. If they plead to a state charge, Madison gets most of it with a little bit to the county. If they plead to a county ordinance, then I think more of it stays in the county. I mean, that's complex. You're going to have to. That's not a judge's discretion. You'll have to go to the legislature.
Restitution gets thrown in there, and so as long as our victims get the restitution back, that's what I first want. And then secondly, I want to go to cops.
And then go to cops. Yeah.
If people post cash bonds, and then they have their court, and then there's restitution. Well, that money. So that somebody has a $500 cash bond, and they broke a window, and the window is $250, and so restitution is $250. The court system will take that $500 cash bond and pay and try to make the victim as whole as possible with that first. So they get the first dollar before fines, before other.
Well, you're not very controversial, John. I was really hoping for
Thank you.
Man, that is crazy. I thought it was going to be like a fireworks show of just, anyway. So that's all. I wanted to make sure we talked about those cash bonds. So ultimately, like, if you could put a bow on it, what would you tell the community when it comes to cash bonds? If they see a $10,000 signature bond versus a $10,000 cash bond, I understand, and I think most people do. This is not the sentence. It's just a repeat. You could take several factors into consideration now. But what message would you want to tell the community when it comes to when you see anything, the dollar amount, signature, or cash? Please make sure you consider this. What would you tell them?
Well, it's not one specific thing. It is the entire circumstantial nature of that particular case. There are no cases that are identical. There are no cases that have the exact, amount of evidence that convinces you, oh yeah, this is a case. And very frankly, you're supposed to just look at, sure, you can look at the strength of it, but you still have to consider their the fact that they're innocent until they're proven guilty. It's I don't know.
It is tough, and this is why I've always struggled with this the whole time, because I understand that there's two different parts, and this is not a sentence or anything. You know what I wish? I just wish that there was like similar cases. I wish there was just a spreadsheet. Okay, you did this, and it spits out a number. There's like an algebraic formula. That's so much easier.
Judges don't have the luxury that perhaps a DA or even a sheriff does of going out and explaining. A sheriff can go out and say, "Hey, look at our guys and gals. They arrested somebody here with a lot of drugs, and they did a great job." Sheriff knows that there's lots of work to be done, and as far as prosecuting that case, but a judge in setting bond, if you're in court, that judge should be explaining why they're setting the bond the way they are. But it's lack of resources. You, Ben, can't sit in all of the sentencings that are in Sawyer County or Washburn County or Burnett County and understand the rationale. You don't want to get the transcripts and and pay the money for the transcript so that you can read the rationale of the judge. You generally go off of minutes, correct, on what happens
Criminal
in court?
complaints and open records, including, CCAP, the notes put in by the court's office, correct.
And that's not really most of the time reflective of why the judge does something.
No, it's rarely. I mean, right. It doesn't provide context. It's just,
Right.
and I'm not saying it necessarily should either. It's just, this is the facts, and that's all we stick with. Here are the facts. Now, the
Right.
why and the context, I have no idea. I'm not there.
If resources weren't a problem, I wish that news reporters were sitting in the
I would
courtroom
love it.
all the time, so that they could give a story as to why the judge did what they did. And this isn't a criticism on you. I mean,
No,
it's
I
like
totally understand. I agree with
that.
that.
Get that information to the public as neutral as possible, but with what you're gleaning from the minutes, you're missing what was the DA's recommendation? Is this a joint agreement?
I know.
What justifies the agreement? Oh, well, hey, guess what? In court, we're giving a wink and a nod because law enforcement, they helped law enforcement pick up other people. Well,
Right.
okay, great. A judge is going to go along with that, generally speaking. And all right, so that justifies it, but that doesn't get reflected in the minutes. And so that's just one small example of why you would, give a certain sentence. And there is just a whole broad context that the general public is missing if you're not sitting in court, listening to what's going on and the rationale. And newspaper people try the best that they can, the good ones, to reflect accurately what's taking place. But even when they do that, their questions come up and then there's just assumptions made. And so it is one of the most misunderstood parts of our community as to what's going on. It's complicated. Sometimes the criticism is justified. A lot of times it's not. For particular judges, for particular DA's office, for particular defense attorneys, public defenders. And I would just ask that the public be more aware when they are offering their criticism. Just be more aware of it. If you're really having a problem with it, go talk to players in the system. Educate yourself a little bit more on what our general procedures are. And that's, I guess, one of the reasons why I always enjoy going on your show. If I can help people understand how the system works a little bit better just through our conversations, hey, then I'm doing my job, at least in part, of trying to explain the court system. I think the worst thing we could do as sheriffs or DAs or judges is to just do our job and then be silent to the public about how it works.
Yes,
and
thank
I
you.
agree. That's why we do the show.
Yeah, Fitz and I have talked about this many times. Yes.
And sometimes I have to go upstairs and because I agree with you, Judge. Sometimes we don't even, as law enforcement, take that into account. We're like, why did the DA do that? And we run upstairs and pound on the fence, and then we're like, oh, that kind of makes sense. Sorry. But then we have to come down and we have to, as administrators, to make sure we explain it to our patrol guys so that they don't get, scorned by the system. And so we have to do a good job internally and then externally. And that's why I do this show every week, is to put some of this information out there to the best of my ability to get it to people. I really appreciate you coming on. It's been awesome.
Oh, yeah. Well, and I mean, with law enforcement, that's the case. I mean, you have different law enforcement agencies that I'm dealing with, in a county. And, why did this case get such a light sentence? Well, you weren't there when the DA basically said, law enforcement maybe in this situation didn't quite go through all of the steps that they needed to, so the case is not as strong as it should be. Yeah. And if we take it to trial, we're going to lose. And the defendant has agreed to at least, shortchange.
Right.
Those are all things that the public's not privy to. And it's so many things. So I always tell law enforcement officers, the young ones that come in and they're introduced to me, I'm like, hey, come in anytime you want to. Talk about preliminary hearings in general. Talk about testifying. Talk about the importance of getting your reports done so that the DAs can proceed with that. I mean, there have been times where I've set somebody on a cash bond, waited 7 or 8 days before we had an initial appearance, and they still did not get the report from law enforcement officers. So I'm like, that they can't sit there forever without a charging document. So I've vacated the bond and put him on a signature bond because the law enforcement officer didn't get the report to the DA. I mean, not to throw anybody into the bus, but we're all busy. We're all doing the best that we can.
Right. Agree, 100%.
So real quick, I want to ask you, you're talking about sheriffs and your relationship with law enforcement as a judge. And Fitzy, I want to ask you this too, because I believe that you have a relationship with, or I should say communication with the judges down in Barron County. John, could you kind of speak to the importance of that, of having that open door? And as a judge, is there times where it's, well, maybe, it's a conflict of interest, not a conflict of interest, that the public may look at this and say, maybe you shouldn't be, talking to law enforcement. There's a process here. Or is it important to make sure that you and Sheriff Moreau-Tech, not necessarily on the same page, but there is an open line of communication about things? Speak to the importance of that relationship.
Well, absolutely. I mean, you don't. I don't sit there and talk with my sheriff about individual cases and what takes place. But if there was a specific case where I had to modify the bond, because there wasn't a report, I just sent a note to the sheriff just saying, hey, you know what, I had to do this one. I mean, I don't like it. I know the sheriff doesn't like it. And, I just throw it over to him, because then it's in his realm to try and figure out, is this something internally that we need to take a look at? Is it a one-time thing? Somebody gets sick and had to go and rush off before it got done. There's explanations for everything. And so, to have that communication just helps the system work better. Obviously, the sheriff is closely connected to the court system with security and with the jail, getting individuals who are in custody into the court. And so we have a close relationship, the judges do, with the jailers and the jail lieutenant, and making that whole process work so that we're not sitting there going, well, this person's in custody, where are they? It's 15 minutes past their case time. And so when things break down or things happen, that communication is important, because if you're sitting there, if that communication breaks down, it can grind the system to a halt, and people get frustrated. And if the communication is open, it works so much better.
Fitzy, you agree? I'm assuming you agree with that, because you've talked with them on the show.
Yeah, I have a relationship, again, not about specific cases. I don't go up there and say, why did you do this on this person? No, it's about making the system better, whether it's a treatment court or things we don't agree with that. It's like, we got to do this better, and so, if you don't have that relationship and an open relationship, nothing's going to succeed. So you have to continue that. Yeah. And again, it can't be about a specific case. The judges don't talk about specific cases. So, but it's
they're pretty uptight that way. Jeez.
Yeah. By law, they have to be. Yeah, that's a good thing for them to be.
I suppose. All right. Well, we've already blown past our time, so we need to wrap it up here. Fitzy, what do you have coming up this week?
It's lots of meetings this week, and just getting some stuff ready before the holidays, and that's what we're doing. So.
Yeah, and by the way, you gotta let me know when you're wearing a suit, because I'm literally wearing my Superman T-shirt and you're in a suit. I need to get a tie or something when you gotta let me know. We have to coordinate our outfits.
That's all right. I did. Yeah, it was a last minute thing this morning. I got meetings all day. So.
All right, John, what do you have coming up this week?
Just trying to do last minute Christmas shopping. That'll be on the weekend, because just got cases throughout the rest of the week, and then a fairly busy week next week, and then kind of just doing in custodies for the between Christmas.
What are you talking? We got 2 judges now. Again, you only work 2.5 days a week. All right, just be clear, that's not true.
I had to clear that up, Ben. Just so you know, that's not what that means. I know you're joking, but I don't want the listeners to think that's what that means.
No one ever takes the things we say in the show out of context, ever.
So, no, what this additional judge means is that we are now better able to address all of the things that we were unable to address. Back before the second judge started, we were focused on getting the biggest felonies through the court system, doing all those things, and to address that first. Well, so much other stuff was neglected. Now we're able to start refocusing in on everything and to maintain a healthy system.
Spending time on these cases and trying to make a difference in someone's life. And when it comes from a judge, it can, when a cop says, don't do this again, but when a judge says, don't do this again, and they take some time to understand the case, and it means a lot. So I applaud you, Judge, for what you do. I know sometimes cops and judges don't see it on the same page and vice versa, but I appreciate you coming on. What you've given the community here and some background into it is is priceless. So it's great. I appreciate it. So
for the job
because just like when Fitzy comes on, I've thanked Fitzy so many times for being transparent, and sometimes people don't like that he comes on and does these live shows, and we'll talk about things at length, opportunity to talk about whatever. You're the only judge we've ever had on the show, and it's not that we haven't asked a few. So just saying, thank you for that. Real quick, here's our weatherman who's giving us the weather forecast. Warm for the week and dry. Today will be the coolest day. High is 25 to 30
40.
under Mosey. Just where's the nice nice weather?
It's going to be a green Christmas. That's what it's saying. We're not going to.
Right. Oh, real quick, I forgot to tell you, Kenneth. I should tell this off. No, I'm just going to say it right now. See your judge's reaction. So after Bible study this last Sunday, when Mom comes over, we always do our Bible study Sunday morning, and we were talking about the weather and crashes. It was kind of a slippery morning that morning. And Kenneth, my 14-year-old son, who speaks quietly and very monotone and very matter-of-factly, and he said, well, did you know that 30% of crashes in Wisconsin are caused by drunk drivers, which means 70% are caused by sober drivers. So statistically speaking, you're safer driving drunk.
No.
I know. He was saying it as a joke, but that was so, I thought of you right away. I'm like, I totally got to tell Fitzy that because, hey, stats don't lie, man.
No. Kenneth should go back to school.
Oh, my goodness. John, thank you so much for coming on, Fitzy.
Thank you. Merry Christmas.
All right. For Barron County Sheriff Chris Fitzgerald, I'm Ben Dryden. You've been watching Positive Tuesday with Ben and Fitzy, presented by Professional Exteriors and Interiors. With 20 years of experience as locally owned and operated business who provides quality work both on the inside and on the outside of your home or business. Give them a call today. See what they can do for you. 715-520-2271. Special thank you to Sawyer County Judge John Yackel for coming on and, talking shop today. Fitzy, I believe you're off next week, right?
I am.
All right, good, because I got somebody filling in for you. Okay. That'll be Washburn County District Attorney Aaron Marco will be filling in for you next week. So until then, thank you for watching, and as always, have a blessed day.